SFG Essential, Current Affairs, Polity SC Verdict on Governor's Assent to Bills. News. In a landmark judgment, the Supreme Court struck down Tamil Nadu Governor R. N. Ravi's decision to withhold assent to 10 state bills, terming it illegal and erroneous in law. Key highlights of the SC judgment. No absolute or pocket veto allowed. The court ruled that there is no concept of absolute veto or pocket veto under Article 200 and stated that governors cannot indefinitely delay action on bills. Absolute veto. Governor withholds assent to a bill passed by the legislature. Pocket veto. Governor neither assents to nor rejects the bill, keeping it pending indefinitely. Represented bills cannot be sent to the president. If a bill is returned by the governor and the legislature repasses it without any changes, the governor must give assent. The option to refer it to the president arises only if the bill is substantially altered. Governor must follow state government's advice. The court held that the governor has no independent discretion and must act on the aid and advice of the Council of Ministers. Timelines for action. The court laid down specific timeframes for the governor to act under Article 200 to prevent unnecessary delays. Any violation of these timelines could make the governor's inaction subject to judicial review. Timeline for governor's action under Article 200: 1 month, 3 month, 3 month, 1 month. Withholding assent or reserving for the president, the governor must act within 1 month returning the bill with a message. If withholding assent contrary to Council of Ministers advice, the governor must return the bill within 3 months reservation of bills for the president. Contrary to advice of the State Council of Ministers, must be done within 3 months. Granting assent to represented bills must be done within 1 month. Assent to bills under Article 200. Article 200. It specifically deals with the issue of granting assent to bills. As per Article 200, when a bill is passed by the state legislature, the governor has 4 options. A. Grant assent. B. Withhold assent. C. Return the bill, except money bills, for reconsideration. D. Reserve the bill for the president's consideration. Key provision in Article 200. Article 200 states that the governor must return a non-money bill as soon as possible with a message for reconsideration. If the legislature passes the bill again, the governor is constitutionally bound to grant assent. However, since no specific time frame is prescribed for the governor's action, which creates a loophole. Presidential reference under Article 143. News. President Draupadi Murmu made a reference to the Supreme Court under Article 143, seeking its opinion on 14 specific legal questions. This move comes after a recent Supreme Court judgment that prescribed timelines for governors and the president to act on state legislation and made such decisions subject to judicial review. About Article 143 of the Indian Constitution. Article 143 deals with the advisory jurisdiction of the Supreme Court and empowers the President of India to seek the court's opinion on any matter of law or fact that is of public importance, whether such an issue has already arisen or is likely to arise. This jurisdiction is exclusive to the President and enables the executive to obtain authoritative legal advice from the judiciary. Types of matters referred under Article 143. Article 143. 1. The President may refer to the Supreme Court any question of law or fact of public significance, whether it has arisen or is likely to arise. The Supreme Court has the discretion to either tender its opinion or decline to do so. Article 143. 2. This clause permits the President to refer matters related to pre-Constitution treaties, agreements, covenants, sannads, or similar instruments. In such cases, the Supreme Court is obligated to provide its opinion. Presidential reference. Key features. The President exercises this power based on the advice of the Union Council of Ministers. As per Article 145(3), any reference under Article 143 must be heard by a bench of at least 5 judges of the Supreme Court. Nature of the opinion. In both types of references, the Supreme Court's opinion is advisory in nature and not binding on the President. The President has the discretion to accept or disregard the court's advice. Historical background. The concept of advisory jurisdiction under Article 143 has its roots in the Government of India Act, 1935, under which the Governor-General had similar powers to consult the federal court on legal matters. Personality rights news. The Delhi High Court has protected Sadhguru Jaggi Vasudev's personality and publicity rights, restraining rogue websites from misusing his image using AI. About personality rights. Definition. Personality rights refer to the legal rights of an individual to protect their unique personal attributes, such as name, image, likeness, voice, signature, or other identifiable traits from unauthorized use, especially for commercial purposes. Types of personality rights. Right to privacy. Protects an individual from unauthorized intrusion or disclosure of their personal life. Recognized as a fundamental right under Article 21 of the Constitution, Justice K.S. Puttaswamy v. Union of India, 2017. Right of publicity. Gives an individual control over the commercial use of their identity, e.g., name, image, likeness. Prevents unauthorized commercial use for advertisements, merchandise, or endorsements without consent or compensation. Legal status in India. No dedicated statute. There is no single law exclusively governing personality rights in India. Protected through Trademarks Act, 1999, Section 14 restricts unauthorized use of an individual's name or representation for commercial purposes. Copyright Act, 1957, provides indirect protection through the doctrines of passing off and deception under intellectual property rights, IPR. Common law principles. Courts apply privacy and property rights principles to protect an individual's persona. Official language. News. Union Home Minister addressed the Golden Jubilee celebration of the Department of Official Language in New Delhi as the chief guest. It was established in 1975 about official language. Definition. The term official language denotes the language or languages that a government uses for administration, official communication, and public records. Constitutional provisions. The provisions related to the official language are contained in Part 17 of the Constitution of India. Article 343 declares Hindi in the Devanagari script as the official language of the Union. However, under the Official Language Act, 1963, English shall continue to be used for all official purposes of the Union and for the transaction of business in Parliament, along with Hindi. Article 344 provides for the constitution of a commission and a committee of Parliament on official language to make recommendations for the progressive use of Hindi for official purposes of the Union. Article 345 empowers the legislature of a state to adopt any one or more languages in use in the state or Hindi as the official language of that state. The 8th schedule to the Constitution enumerates the recognized languages of India. At present, it includes 22 languages, namely Assamese, Bengali, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Malayalam, Manipuri, Marathi, Nepali, Adiya, Punjabi, Sanskrit, Sindhi, Tamil, Telugu, Urdu, Bodo, Santhali, Maithili, and Dogri. Notably, there are no specific constitutional criteria laid down for the inclusion of a language in the 8th schedule. Deputy Speaker of Lok Sabha. News. The position of the Deputy Speaker has been lying vacant for the last 6 years, raising questions on constitutional adherence and democratic resilience. About Deputy Speaker of Lok Sabha. Constitutional basis. Article 93 of the Constitution mandates that the Lok Sabha shall, as early as possible, elect 2 members from among itself to serve as the Speaker and Deputy Speaker. Article 94 outlines the conditions under which the Speaker or Deputy Speaker may vacate office, including resignation, removal, or ceasing to be a member of the House. Article 95(1) states that in the absence or vacancy of the Speaker's office, the Deputy Speaker assumes all functions and exercises equivalent powers while presiding over the House. The rules of procedure and conduct of business of the Lok Sabha clarify that any mention of the Speaker shall also apply to the Deputy Speaker whenever they are presiding over proceedings. Article 178 provides a parallel framework for the offices of Speaker and Deputy Speaker in the state legislative assemblies. Election of Deputy Speaker. The Deputy Speaker is elected by the members of the Lok Sabha from among themselves by a simple majority of those present and voting. The election is governed by the rules of procedure and conduct of business of the Lok Sabha. The Speaker is responsible for deciding the date for electing the Deputy Speaker. No separate oath is prescribed for the Deputy Speaker. The oath taken as a member of Parliament, as per the 3rd schedule, is sufficient. Note: usually, the Speaker is chosen from the ruling party or ruling alliance, while the Deputy Speaker is selected from the opposition party or opposition alliance. However, there have been exceptions to this convention. Tenure and removal. The Deputy Speaker holds office for the duration of the Lok Sabha's term unless they resign by submitting a written letter to the Speaker, cease to be a member of the Lok Sabha, are removed through a resolution absolute majority passed by a majority of the total membership following a 14-day notice period. If the office falls vacant, a new Deputy Speaker is elected by the House. Historical context. The office emerged in 1921 under Government of India Act, 1919. Sachinanda Sinha first held this office in the Central Legislative Assembly. Post-independence, M. Ananthasainam Iyengar was elected as the first Deputy Speaker of the Lok Sabha. Estimates Committee News. Lok Sabha Speaker inaugurated the National Conference marking the Platinum Jubilee of the Parliamentary Estimates Committee in Mumbai's Vithan Bhavan complex. About Estimates Committee. The Committee on Estimates was constituted for the first time in 1950. Members. It consists of 30 members, elected every year by the Lok Sabha from among its members. Election. Members are elected according to the principle of proportional representation by means of the single transferable vote. Chairperson. The chairperson of the committee is appointed by the Speaker from among its members. A minister cannot be elected as a member of the committee, and if a member, after being selected to the committee, is appointed a minister, the member ceases to be a member of the committee from the date of such appointment. Term of office. The term of office of the committee is 1 year. Functions. The functions of the committee are enshrined in Rule 310 of the Rules of Procedure and Conduct of Business in the Lok Sabha. The functions of the Estimates Committee are to report what economies, improvements in organization, efficiency, or administrative reform consistent with the policy underlying the estimates may be effected, to suggest alternative policies in order to bring about efficiency and economy in administration, to examine whether the money is well laid out within the limits of the policy implied in the estimates, to suggest the form in which the estimates shall be presented to Parliament. Exceptions. The committee does not exercise its functions in relation to such public undertakings as are allotted to the Committee on Public Undertakings by the Rules of Procedure and Conduct of Business of the Lok Sabha or by the Speaker. Registered Unrecognized Political Parties, RUPs. News. The ECI has initiated steps to delist 345 registered unrecognized political parties, RUPs, that have not contested elections in the last 6 years. About registered unrecognized political parties, RUPs. Definition. RUPs are political parties registered with the Election Commission of India, ECI, under Section 29A of the Representation of the People Act, 1951. But they have not yet fulfilled the conditions to be recognized as a state or national party. Key features. They may be newly registered parties or parties that did not secure the minimum required vote share or seats in Assembly or Lok Sabha elections to gain state party status, or parties that have never contested any election after registration. Symbol allocation. A common election symbol is allotted to RUPs under Para 10b of the election symbols, Reservation and Allotment, Order, 1968. To receive this, the party must undertake to field candidates in at least 5% of the total seats in a state legislative assembly election. Conditions and compliance. RUPs must maintain details of all individual donors contributing above 20,000 rupees in a financial year and submit these records to the ECI annually, Section 29C, RP Act. Noncompliance may lead to loss of income tax exemption under Section 13A of the Income Tax Act, 1961. Donations above 2,000 rupees must be accepted only via check or bank transfer. They must submit audited accounts for the last 3 financial years and expenditure statements for the previous 2 elections. Benefits. Income tax exemption for donations under Section 13A, Income Tax Act, 1961. Eligibility for a common election symbol for Lok Sabha or state assembly elections. Permission to nominate up to 20 star campaigners during election campaigns. Issue of letterpad parties and delisting. As of May 2025, India has over 2,800 RUPs, but only about 750 contested the 2024 general elections. Representation of the People Act, 1951 not empower the ECI that does to deregister a political party merely for not contesting elections, not holding internal elections, or failing to submit reports. In Indian National Congress versus Institute of Social Welfare and ORS, 2002, the Supreme Court held that the ECI can only deregister in exceptional cases such as registration obtained through fraud. The party ceases allegiance to the Constitution. The party is declared unlawful by the government. Framework for extradition in India. News, 2611 accused Thahavur Rana was recently extradited to India from the USA under the bilateral extradition treaty between the 2 countries. About framework for extradition in India. Extradition is the formal process by which one country surrenders an individual to another country for prosecution or punishment for crimes committed within the jurisdiction of the requesting country. In India, extradition is governed by the Indian Extradition Act, 1962. It is typically carried out under the framework of a bilateral treaty between the 2 countries involved or a broader multilateral treaty. The Ministry of External Affairs is the nodal ministry responsible for handling extradition processes in India. The Government of India finally decides on extradition, and this decision can be appealed in a higher court. According to the Ministry of External Affairs, India currently has extradition treaties in force with 48 countries and non-binding extradition arrangements with another 12 countries. Who are the Rohingyas? Rohingyas are an ethnic Muslim minority from Myanmar's Rakhine state. They have long faced violence, persecution, and denial of citizenship in Myanmar, making them the world's largest stateless population. Many have fled to neighboring countries, including India, Bangladesh, Malaysia, and Thailand. India's approach to refugees. No specific refugee law. India does not have a separate legislation to deal with refugees. Refugees are treated under general immigration laws as foreigners or illegal migrants. India is not a signatory to the 1951 UN Refugee Convention, the 1967 Protocol relating to the status of refugees. Key legal provisions in India related to refugees and deportation. Foreigners Act, 1946. Section 3 authorizes the central government to detain and deport foreign nationals staying illegally. Provides broad powers to prohibit, regulate, or restrict entry or stay of foreigners on grounds like national security. Passport Entry into India, Act, 1920, empowers the center to remove any foreigner who enters India without valid documents, passport, and visa. Constitutional provisions, Articles 258, 1, 239, 1. Under and states and union territories are entrusted with powers to execute deportation under central laws. Supreme Court's position on Rohingyas in recent cases on Rohingya deportation, the Supreme Court clarified. Article 21, Right to Life, and Article 14, Equality, apply to all persons, citizens or foreigners. However, Article 19(1)(e), only to right to reside and settle, is available. Indian citizens. Therefore, Rohingyas cannot claim the right to settle in India. UNHCR refugee cards do not grant legal status under Indian law. Cabinet Committee on Security, CCS. News. Following the Pahalgam terror attack that claimed 26 lives, the Cabinet Committee on Security, CCS, unveiled a set of unprecedented retaliatory actions targeting Pakistan. About Cabinet Committee on Security, CCS, it is the apex decision-making body in the government of India on matters related to the country's defense, national security, and law and order. It is also the apex body when it comes to the appointments of the officials in the national security bodies. Composition. The committee is chaired by the Prime Minister and comprises key ministers holding strategic portfolios. Minister of Defense, Minister of Home Affairs, Minister of Finance, Minister of External Affairs. The National Security Advisor, NSA, acts as secretary-level coordinator on matters within its purview. The Cabinet Secretariat is responsible for maintaining records of all the meetings and proceedings of the CCS. Functions of the CCS. It discusses different initiatives to take to enhance the national security of India. It deals with all issues related to the law and order and national security of India. Discusses political developments with national security implications. Evaluates foreign policy decisions with a bearing on security. Evaluating international agreements related to defense and security. About Cabinet Committees. Cabinet committees are extra-constitutional bodies, i.e., they are not provided for in the Constitution of India. Their primary purpose is to streamline governance by reducing the workload of the Union Cabinet, allowing smaller groups of ministers to take decisions in specific domains. These committees are constituted or reconstituted by the Prime Minister based on emerging needs. Current cabinet committees include Security, Economic Affairs, Political Affairs, Investment and Growth, Parliamentary Affairs, Accommodation, Employment and Skill Development, and the Appointments Committee. National Security Advisory Board, NSAB. News, Central Government has revamped the National Security Advisory Board, appointing ex-RA Chief Alok Joshi as its chairman. About National Security Advisory Board, NSAB. It is an advisory body comprising eminent experts from outside the government that provides long-term strategic inputs on national security issues to the National Security Council. It is part of India's three-tier national security management system, which includes National Security Council, SC, headed by the Prime Minister. Strategic Policy Group, SPG, chaired by the National Security Advisor. National Security Advisory Board, NSAB, provides advisory inputs on strategic and security matters. Legal mandate. It is neither a statutory body nor a constitutional body. It operates under the framework of the National Security Council. Secretariat, NSCS. Its recommendations are advisory in nature and non-binding. Meetings. The board generally meets at least once a month, or more frequently if required, depending on the urgency of the issues. Tenure. Initially, the board was constituted for a one-year term. Since 2004 to 2006, it has been reconstituted for a two-year term. Civil Defense under the Civil Defense Act 1968. News. Amidst heightened tensions between India and Pakistan, the Union Ministry of Home Affairs, MHA, issued instructions to all states and UTs to conduct a civil defense mock drill on May 7, 2025. About civil defense. Civil defense, also known as civil protection, refers to organized government efforts to safeguard civilians during emergencies such as wars, terrorist attacks, natural disasters, or major accidents. It includes core emergency functions like prevention, mitigation, preparedness, response, evacuation, and recovery. Legal framework in India. Civil Defense Act, 1968, introduced after the Indochina and Indo-Pak Wars to formalize civil protection measures. 2009 Amendment, Act No. 3 of 2010 broadened the scope to cover disaster management in addition to wartime duties. Powers of the central government. Frame rules for civil defense nationwide. Implement evacuation plans and control hazardous substances. Oversee disaster relief efforts. Impose penalties for violations of civil defense regulations. 50th anniversary of Sikkim statehood. News. Prime Minister of India greeted the people of Sikkim on the 50th anniversary of its statehood. Constitutional milestones. Associate State, 1970 for the Constitution, 35th Amendment, Act, 1970 for Associate State, Article 2A. Granted Sikkim the status of an under. Full statehood, 1975 May 16, 1975, Constitution, 36th on the Amendment, Act 22nd State of India, Article 2A made Sikkim the and was repealed. Special status. Article 371F of the Constitution provides special provisions to safeguard Sikkim's distinct legal, cultural, and land rights. Key achievements and features. First 100% organic state. Sikkim is India's first fully organic state and a pioneer in sustainable agriculture. Biodiversity hotspot. Located in the Eastern Himalayas, Sikkim is part of a major biodiversity hotspot and is home to unique species such as the red panda and the Himalayan blue poppy. Civil Registration System, CRS. News. In 2022, around 86.5 lakh deaths were registered in India, significantly lower than the 2021 peak caused by the COVID pandemic. About Civil Registration System, CRS. Popularly known as the Birth and Death Registration System, CRS records vital events, birth, death, and stillbirth, on a continuous and permanent basis under statutory provisions. CRS falls under Entry No. 30 of the concurrent list of the Constitution of India. Nodal Ministry, Ministry of Home Affairs, MHA. Legal framework, governed by the Registration of Births and Deaths, RBD, Act, 1969, amended in 2023. Registration of births and deaths is mandatory under this act. Births, stillbirths, and deaths must be registered at the place where the event occurred within 21 days. It will measure how well these grassroots institutions are achieving localized sustainable development goals, SDGs. Themes and indicators. The PAI is based on 435 unique local indicators spread across 9 thematic areas. Performance categories. Achiever, 90+ points, none qualified this year. Frontrunner, 75 to 90 points, 699 panchayats, 0.3%. Performer, 60 to 75 points, 77,298 panchayats, 35.8%. Aspirant, 40 to 60 points, 32, 392 panchayats, 61.2%. Beginner, below 40 points, 5,896 panchayats, 2.7%. Top performers, Gujarat led with 346 frontrunner panchayats, followed by Telangana with 270 frontrunners. E0 FIR. Context. The Ministry of Home Affairs, MHA, has started a pilot project in Delhi for the E0 FIR system. About E0 FIR launch and purpose. Pilot project launched by MHA in Delhi to speed up police action in cyber financial frauds over 10 rupees lakh. Developer. Created by the Indian Cybercrime Coordination Center, I4C, under MHA. Reporting options. Complaints can be filed through the National Cybercrime Reporting Portal, NCRP, or 1930 helpline. FIR mechanism. FIR is digitally registered by Delhi's e-crime police station and electronically transferred to the concerned local police station. Legal framework, based on sections 173(1) and 173(1)(2) of the Bharatiya Nagarik Suraksha Sanhita, BNSS, 2023. Jurisdiction-free. Victims can file FIRs without being restricted by police station boundaries. Key features. Automatic registration. FIRs auto-registered for frauds above 10 rupees lakh. Remote access. Victims can report from anywhere. Follow-up requirement. Victims must visit a cybercrime police station within 3 days to convert zero FIR into regular FIR. SNet. Context. The Election Commission of ECI, India, will soon launch a single-point app SNet for stakeholders. About SNet. SNet has been developed as a unified digital interface to deliver all election-related services to voters and other stakeholders through a single platform. Key features. It offers an appealing user interface, UI, and a streamlined user experience, UX, by integrating various electoral activities under one roof. Users can conveniently access essential election-related information and services on their desktops as well as smartphones. To maintain data integrity and authenticity, only authorized officials of the Election Commission are permitted to enter and update information on SNet. SNet will consolidate and replace multiple existing applications such as the Voter Helpline app, Voter Turnout app, C-Vigil, Suvidha 2.0, ESMS, Saksham, and KYC app, which together have already recorded over 5 crore downloads. Campus Calling context. Recently, the National Commission for Program Women NCW launched the Campus Calling Initiative. About the program, it is an NCW initiative designed to promote safe and inclusive learning environments. It aims to strengthen awareness on gender-relatedness and online threats through structured student engagement. The initiative supports SDG 5, gender equality, and is in line with the National Cybersecurity Strategy 2020-25. It also complements the Cybercrime Prevention Against Women and Children, CCPWC, scheme. E-Passport. Context. India has joined over 120 countries in issuing biometric e-passports, offering enhanced security, faster immigration, and global compliance. About E-Passport and e-Passport is an upgraded version of the traditional passport with a built-in radio frequency identification, RFID, chip, and antenna embedded in the back cover. The chip securely stores personal details, name, date of birth, passport number, etc., biometric data, facial image, fingerprints, a digital signature for secure authentication. SFMITVA scheme context. The SFMITVA, survey of villages and mapping with improvised technology in village areas, scheme has completed 5 years of its launch. About SFMITVA scheme. The SFMITVA scheme launched in 2020 is implemented with the collaborative efforts of the Ministry of Panchayati Raj, State Revenue Department, State Panchayati Raj Department, and Survey of India. Major components of the scheme includes establishment of continuously operating reference stations, CORS, network. Establishes ground control points for accurate georeferencing and land demarcation. Drone mapping. Survey of India maps rural inhabited areas using drones to create accurate property maps for issuing ownership rights. Information, education, and communication, IEC, initiatives. Awareness programs educate local populations about the scheme's methods and benefits. Gram Manchitra enhancement. Digital spatial data from drone surveys powers analytical tools for Gram Panchayat development planning.